CPRA, it is basically focused on expanding the scope of the existing California Consumer Privacy Act. Within the legislature, the name of the act is still California Consumer Privacy Act. You will find that the amended versions that have been brought about by the CPRA have already been added and amended onto the main body of the law, right? Now, again, it does not replace CCPA, but it simply amends it, right? It was, it is basically called as Proposition 24, right? Which was brought up in the ballot and the vote was casted to make it into a law in the 2020 US general election, right? Under the CPRA, we have certain other amendments, which we will also talk about as the slides go on, but also that they have established a body known as the CPPA, or the California Privacy Protection Agency, right? California Privacy Protection Agency is the name of this government body whose core duty is basically to safeguard the private and digital rights of California residents. Obviously, as we have already discussed in the past multiple times, that in the USA, every individual, every entity is to be governed under the laws of the state in which they are residing or they are incorporated, right? So obviously the CPRA or the CCPA is only going to govern the residents of California, the ones who have a physical street address in the state of California, right? Who does the CPRA applies to, right? Obviously now we need to understand. So this is also something that was modified in comparison to the CCPA, right? The eligibility requisites under this CCPA have been modified a bit under the CPRA. So it applies to any for-profit organization doing business in the state of California, right? Which means that any non-profit organization is automatically exempted from its ambit, right? So it is only going to be applicable on a for-profit organization which is incorporated and doing business in the state of California. Now, this organization has to have a gross annual revenue of more than 25 million USD in the preceding calendar year, buying, selling, or the sharing of personal information of 100,000 or more Californian residents or households each year, or they earn 50% of more of their annual revenue from selling or sharing such personal information, right? So the ambits of CCPA now has been narrowed down to cover only specific for-profit organizations incorporated into the state of California that are obviously doing a very large business and are handling a large volume of personal information, right? So they have a higher degree of adhering to privacy obligations, right? Because they are also then selling or bartering such personal information with various third parties, with hundreds and thousands of third parties, right? Which is why the obligation or the highest degree of care has been placed on such organizations, right? What can be the reason behind exempting? So the reason comes from actually section 1798.83 of the California Civil Code, which talks about customer records. Now they have clearly said that any personal information to be used for any charity objectives will be exempted from the privacy laws, right? Because in that case, the personal information is not being sold for any consideration and it is only being shared to achieve charitable objectives, right? Which is why non-profits are exempted. Does the act apply on third parties as well who are buying this personal? Absolutely. So in the sense only if, so see, it is not going to be applicable on the third parties because the privacy policy needs to be drafted keeping in mind the website or the company that is collecting the private information. The only safeguards that you can provide under these laws are essentially authorization or consent from the user to the entity or to the website to then ultimately sell or share their personal information, right? Which means that if the website needs to, share or sell this personal information to any third party, they need to take explicit authorizations, right? Those third parties again will be will be governed by their own privacy policy. For example, when say you have gone on Amazon, right, and you want to buy bags on Amazon, right? Now you'll also see, because this has happened with me and a lot of the friends that I know. Say if I go on Amazon and I look for bags, right, tomorrow when I say I am scrolling through Facebook, and I kid you not, I will find in fact similar bag advertisements on Facebook itself. Has this ever happened to any of you? Right, like you have used, or you have tried to look for that product on a different platform, and some other platform is kind of showing you the same advertisements, right? So now these other platforms are going to be governed by their own privacy policy. Yes, they are done through cookies or even web beacons, right? So then in that case, Facebook is to be governed by its own privacy policy, which will also place similar stringent obligations of privacy on Facebook, right? So each of the law is applicable to each of the entity, and the way to comply with privacy laws is to ensure that there is a privacy policy on the website. Has anybody seen this? Any website in today's age that you want to open, any website, okay, it is going to have two documents, either at the very end of it or at the very top of it. There are two documents that are essentially, they are called one-sided contracts, because we as a user have no negotiating power under the terms. We only have the option to say yes or no. What are these two documents, guys? Every website, yes, privacy policy and terms of use, right? So the way to make sure that your company is compliant with the privacy laws is to ensure that you execute a privacy policy onto your website, making sure that all the provisions are in compliant with the laws. Right? So that is exactly the reason. Now they will be only applicable to every entity that executes its own privacy policy. Now we'll also see what are the comparisons between what was originally there under CCPA and now what has been brought about under CPRA, right? So the number of households firstly was 50,000. Now it has been increased to 100,000 or more California residents or households, right? Secondly, the new law now applies to businesses that generate 50 or more of their revenue from sharing personal information. So previously, the kind of calculation of this would be where the entity is, receiving more than 50% of its annual revenue from just selling the personal information, right? Only when they have sold the personal information and their income is more than 50% of their annual turnover, in that case, this law would be applicable to them. But now this has widened the scope of it, where any entity that earns this money not only from selling but also sharing personal information would also be attracted under the CPRA, right?